So up next we have my dear friend Kulufelo. I have to read her bio. We've been friends for 10 years, but like she does a lot, so I have to read her bio. She's going to speak to us about wills. I did mention earlier that when you are in mourning, there's an aunt who comes to the house and she never leaves. There's an estranged husband who comes back with Nyazi saying that this is my house. There's a lot of things that go on if you don't have a will or if your parents don't have a will in place. And having estate planning is a method of investing. And again, estate planning is a method of investing, but it's also a method of understanding how your assets and liabilities are positioned, and you can obviously make better decisions for your children, for your own future. So Kulufelo Sekele is an attorney who specializes in telecommunications law, as well as corporate and commercial law, with an extensive background in dispute resolution. She's currently working as a legal specialist at one of Africa's largest telecos. It's not Telkom, by the way. Our fellow sister-in-law had her fair share of courtroom battles relating to commercial property and family law matters. She's passionate about sociopaths. Huh?
Huh? I'm not. You need to explain.
About socio-economic justice.
Really?
Sorry. Youth and community empowerment. Earlier in her career, when she was a candidate attorney, she literally headed the family law department. She did a lot of court-based work, litigation, property, family law issues, and a little bit of divorce. She's drafted numerous wills for families, and she's also assisted families with maintenance applications and various family law disputes. Yes, her roundtable discussions with families regarding childcare, and has drafted numerous wills throughout her practicing career. Please welcome Kulufelo to the podium.
Hi, ladies.
Hello.
Sorry. So it's actually wills and estate plan. So with intestate, that's when you die without leaving a will. When a will is found to be invalid by, there's two instances. It's either you die without leaving a will, or you didn't draft it, or the will is found to be invalid by the master of the High Court. So examples of intestate successions, it's governed by the Intestate Succession Act. So the first example would be a deceased will be survived by a spouse or spouses, but not by a child, a descendant. Second one would be a deceased survived by a descendant, but not by a spouse. Many instances, there'll be siblings, but basically you dying without there being a will. So how an intestate estate devolves when you're married in community of property. Okay. All right. So there's something called a child share for the spouse, and this works with polygamous marriages as well. Guys, if you have a child or you're married, you must have a will. Otherwise, your stuff is just going to go to the master, and they're going to distribute it to the next, basically the next dependent, either your spouse or your spouse and kids. So I'll just teach you now. This is very important. How to calculate a child share. I'll just go back to the previous slide. So it'll be the value of the estate divided by the dependents, so your children, plus the spouse. So let me give you numbers, just to make this more practical. So if the value of the estate is 500,000 rand, and you have 2 kids and 1 surviving spouse, so you have a wife, 2 kids, and you left 500,000. Well, the value of your estate is 500,000. The child share will be 250,001 rand. That will be your child share. So that will go to the spouse, and then the rest will be shared amongst the surviving spouses, right? I don't know if you want to imagine. Surviving dependents, the children. So, have you dealt, I just want to rope, sorry, I want to rope Dumi in. Have you dealt with intestate succession? Yes. Can I say something?
It's fine.
No, you can say
No,
it.
Okay, I was saying.
I prefer to engage. So I know what the fellow said about the questions at the end. You really can engage. Some you can ask your questions now as I go. Yes.
I was saying, I think they start first with if it's 500,000,
Yeah.
then they go to the marriage, what type of marriage it is. So
Yes.
if it's in community, then it's half, then the 250, then will be
Do
shared.
you want to raise your voice?
Okay, I was
Just say
saying.
that again. Sorry.
Okay, I was saying that. Okay, out of the whole 500,
Yes.
it will depend what type of marriage it is first. Then if it's in community for 250, then the 250 will go, if I'm not mistaken.
You are right. So I was
Yeah.
making the in-community property example.
Yeah.
Okay. So obviously with interstate succession, everything depends on how you got married at. And testate really. Before the estate is liquidated, they have to take into account the marital regime first. So everything goes according to that, then you distribute the assets accordingly. Alright, are we on the same page with regards to the child share? It's not really a child share, it's called a child share, but it goes to the spouse. So so how interstate succession devolves when you're married out of community property. They explained all the marital regimes that are out of community property with or without accrual. So it says that if persons are married out of community property subject to the accrual system, then the accrual claim will be first calculated. She explained the accrual claim. So important to note that in case of a marriage in community property, one half of the estate belongs to the surviving spouse or spouses. And although it forms part of the joint estate, it will not devolve according to the rules of interstate succession. So an ANC, antenuptial contract, in respect of a marriage out of commuted property, may contain provisions directly relating to the distribution of the estate. So this will obviously affect how the estate will devolve. So your marriage is actually very important with regards to how your estate will devolve. So firstly, take into account how you get married, and then leave a will once you get married. I personally don't have a will because I do not mind things going to my sister. I don't have a child, I don't have a husband. Things will go there, and I'm very happy with that. But the minute I get a kid or I get married, I will drop the will. It is also not uncommon for spouses married out of community property to be joint owners of assets or businesses such as partnerships and other legal entities. These are important aspects to identify to ensure that each player's legitimate claims are met. You don't want to do joint anything. Advise against. So testate succession is leaving a will. It occurs when a deceased dies and leaves a will. The estate will be distributed as they bequest in the will. However, the will has to satisfy the provisions of the Wills Act. A will is important because it's a legal document that sets out your wishes and the distribution of your assets or properties and the care of minor children. Very important. Creating a will will give you sole discretion over the distribution of your assets. As I said, once you, if you're happy with your family, if you're single, no kids, not married, and you're on good terms with your family, then it's all good. You don't have to do it all. But if you have beef and you're single and you're not getting along with your sibling or whatever, and you know they're reckless and you have assets, then you really should have a will.
What happens if you draft a will and I leave everything? What happens if I draft a will and I leave everything to my sisters, and then I get married and I have 6 children, but I forget to change the will? What happens?
Ooh, they don't inherit. Your kids will not inherit. Your will state, if your will is valid, in the next slide I'll show you what forms a valid will. But if you have not changed your will and you pass away and you have given everything to your sisters in your will, then I'm sorry, everything goes to your sisters. And you hope that you have good sisters that will share the wealth. Yeah. as I said, if you have beef with your family, leave a will. So the requirements of a valid will. Oh, sorry, somebody.
I read somewhere that if you get married and you don't update your will, the old
I'm
one
getting
is
to that.
deemed
I'm gonna
void.
get to that. Okay. So the requirements of a valid will: the testator, who's the person who writes the will, must be over the age of 16. I mean, what does a 17-year-old have? But you never know, you know, generational wealth. Exactly. So the will must be in writing. The testator cannot be the beneficiary of the own estate, obviously. We can't be like, I'm leaving everything to myself after I die. Each page of the will must be initialed or signed by the testator. And the will must be signed by 2 competent witnesses. A person will qualify to be a competent witness if they're 14 years of age or older. So very important, signature, writing down your will. As I mentioned my story earlier, baby girl just had a terminal illness, and she had all these great plans but did not know what formed a valid will. And these are just examples of boilerplate, basically important clauses. So it'll be your particulars, your ID number, everything, so that we know that it's not from wherever. Revocation of former wills, very important. You want to categorically state that whatever was drafted before this, forget about it. This is the valid will. The appointment of an executor. So an executor will administer your estate. Basically make sure everything runs smooth and in accordance with your will.
So, what happens if that executor skips the country or dies or something? Then what? Do you have to have 2 executors as a backup plan?
That's a very good. That's a very
Go
good
to the
one.
master.
Yes.
Oh,
So
okay.
so there's this wonderful office, the master's office downtown in Joburg, and they regulate estates. So if something like that happens where you left a will and the executor dies or whatever before they can even administer the estate, then you take it to the master, they'll make the decision.
Okay.
And they'll nominate an executor.
It's also the master in the high court in the jurisdiction where the deceased was based.
Yes.
So not just Joburg.
The master of
The high court.
the High Court of your jurisdiction. So there's a master of Joburg and there's a master in Pretoria. So it's jurisdiction based. Alright, so what doesn't a will cover? Marital regimes, things like that, like community of property from a marriage, accrual system, proceeds from life insurance policy payouts, retirement assets. Okay, so this is your question at the back. Somebody else? Okay. So what happens when a testator dies after a divorce without having amended his will? This happens a lot. So the Wills Act says that if a testator dies within 3 months, within those 3 months of after having divorced or annulled their marriage, and they created a will before the date of their marriage. They created a will before the date of their marriage having been dissolved, sorry. The surviving spouse will not inherit from the testator's estate. Does that make sense?
So after 3 months, he can get the money.
Okay, so this is what happens after 3 months. Should the testator die after 90 days, so let's say from the 91st day onwards, not having revoked that old will and not having created a new one, then the former spouse will inherit in accordance with the will in place at the time of his death.
Sorry,
Yeah.
can I please just
Yes.
understand that again? So
Yeah.
if we're married, but he had a will before, that didn't include me, that one is the one that goes.
No.
No. So, do you want just ask your question again? If you're married
Yeah.
and then factor in those 3 months
And then
after the divorce.
and then there was a will before the marriage.
Yeah.
Well, that's the
And
one.
he did not amend that,
Update it.
he did not
Yes.
update, then that will is valid. That's the prevailing will.
Oh, okay.
You will inherit. So that's why you have a lot of hits with wives and stuff after divorces. I wanted to go into testamentary trust, but I feel like that's you deal with that a lot, no? Tinashe, but I'll touch on it a little bit.
Give us a like
I'll give you a
principles.
synopsis. So it's a trust contained in a will, which provides for the distribution of all or part of an estate, often proceeds from like a life insurance policy held on a person establishing the trust. There may be more than one trust per will. These are for the benefit of children most of the time. So the trust kicks in after the estate has devolved, post the testator's death. So it's usually, as I said, for the benefit of the children. This differs from a living trust and inter vivo trust, which are created during the lifetime of the testator. So it lasts until it expires, simply put, which is provided for in its terms. Typical expiration dates may be when the beneficiary turns 25 years old or something. So you might put a clause saying, my child will inherit 1 million rand when they turn 18. That's a testamentary trust. And that will be in your will. Just heard that question. Who can be a trustee of a testamentary trust? Literally someone you trust. The person creating the trust may choose anyone. So, but it should be someone they trust, who will act in the best interest of their child. So, I mean, we choose godparents every day, and you'd hope that that's someone that you put in something like this, trust with your children. Thank you. That is it. I hope that helps.